clearly she has violated the terms and conditions of her probation not on one occasion, but on multiple occasions. So for that reason, I find that she is guilty of violating her probation as she admitted, and that an appropriate sentence is to require her to serve 1 year, and following the service of 1 year with credit for time served, she will be returned to active probation, but her probation will be extended for 1 year as well. So she's going to have an additional 1 year to serve on probation, and she'll have 1 year to serve with credit for time served. And that will be the judgment of the court.
Thank you, Your Honor.
Let's go to the Dixon County Jail. And I believe this would be Miss Connie Presley. It is on page 18. Ms. Presley, can you hear me?
Yes, sir.
I think you're represented by Mr. Spratt.
Yes, sir.
Judge, is there any way I could have Miss Presley? I didn't get the docket. I think I've been taken off the list. If I could have her brought down for second call.
Ms. Presley, your lawyer wants you to have you brought down, so I'll have you brought down as soon as we can get you here. So,
Thank you, Your Honor. Thank you, Mr. Lake.
saying he's been taken off the list. I'm not sure what list it is, but
The email list.
public defender represents Ms. Blackwelder.
Yes, Your Honor. This is going to be a hearing, Your Honor. I'm just working out with the state what violations Ms. Blackwelder will admit. Can we proceed on the? We do think at least we would like to be heard on disposition, please.
All right, so are we having a full hearing on whether or not she's violated her probation as well as on disposition, or if she?
No, sir. We're going to proceed just on admitting a violation, and that should be heard on disposition.
All right. Ms. Blackwelder, if you'll raise your right hand, let's place you under oath. Thank you. State your full name for the record.
Emma Lawson Blackwelder.
Ms. Blackwelder, you're here on a violation of probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove that you had actually violated your probation, and they would have to meet the legal standard?
Yes, Your Honor.
You understand if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, Your Honor.
Do you understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals? Now, by pleading guilty, you're waiving your right to contest the issue of whether you are guilty or not guilty of violating your probation. Do you understand that? But you are preserving the right to have a hearing on what should happen to you, more or less. You understand that?
Sure.
You understand that if we have that hearing on the sentencing portion, then whatever I do, you can still appeal what my decision would be and have a lawyer help you with an appeal to the Court of Criminal Appeals. You understand everything I've explained?
Yes, Your Honor.
You want to go ahead and enter a plea of guilty to the charge of violating your probation. All right,
If
and I
I
find
may-
she's guilty, but we'll go ahead and put on the proof about the disposition.
Thank you, Your Honor. And she's signing a plea sheet here, which admits her violation. And specifically, it's the new convictions out of Madison County, Tennessee. Those are in the first amended petition. She's admitting those violations only. But you're going to sit next to me.
All right, you want to call her as a witness?
Yes, please, Your
You'll
Honor.
come around, please, ma'am. You've already been sworn, so just have a seat. So, I changed this.
All right. Would you please state your name, ma'am?
Emma Lawson Blackwelder.
Okay. And you've admitted that you're in violation of your probation, right?
Yes.
And that's because of new convictions?
Yes.
Okay. What were those convictions?
Like the
In Madison County?
simple possession, paraphernalia, and theft.
Okay. And were you sentenced to probation on those?
1129
Okay.
misdemeanor probation.
Okay. And are you asking the court to reinstate you to probation today?
Yes.
Okay. How much time have you spent in jail on this arrest?
4.5 months.
Okay. And is this your first probation violation?
Yes.
Okay. When were you originally put on probation?
In 2022.
Okay. And if you were reinstated to probation, do you know where you would live?
Yes, I have a bed waiting for me at Archangel's Recovery Community House in Charlotte.
In Charlotte, Tennessee, is that right?
Yes.
Okay. And how long would you expect to be there?
I can stay up to 2 years there.
Okay. So you got new convictions. What was the circumstances of those convictions in Madison County?
They just read it at 1129, run concurrent with what I'm doing here.
Okay. And you pled guilty to those charges?
Yes.
Okay. What happened?
In court or?
Just with the charges?
I was living in an Oxford house up there, and my probation officer I had a warrant for here. And so when I asked my friends to come get me to bring me back to here, they came up in a stolen truck and they stole a trailer while they were up there. And I didn't know about it because I'd been in rehab. And so they swarmed us at the gas station, and the dude who was in the truck ran. And so they charged us all with the same thing. And so it was either take it to trial or just take the charges. And so I just took the charges to run concurrent with here so that I could move forward with.
Have you stayed in contact with your probation officer?
Yes, I've reported every month since I've been in jail.
Okay. How about before that, while you were on probation?
I was reporting, and then I went to rehab and stuff. So.
Okay. Did your probation officer know that you were going to rehab?
Here, right, this probation officer?
Yes.
I haven't spoken to her yet.
Okay. And before you were arrested, did you have a job or anything like that?
I was working as a home health care. I was taking care of a lady at home.
Okay. And you said you were arrested approximately 4 months ago, 4.5 months ago,
Yes.
on this violation?
I've been in jail since September 7th.
Okay. And was that on this violation?
Yes.
And do you think that you're going to benefit from going to, you called it Archangels?
Yes.
Okay. What are they going to help you with?
They help you get to and from work. They go to meetings. They drug test. It's a sober community house. So
Okay. Now, you got in trouble, you got new convictions, right? Okay. Are you going to be able to avoid that in the future?
yes,
Okay. What do you think's different now?
I was sober when I came to jail. I just got out of rehab, and so going to meetings and getting a sponsor and changing the way that I live and who I hang out with and the people, places, and things, I think it makes a big impact. And I'm just ready for something different in my life.
Okay. So you think that you would be successful on probation?
I do. I think I could complete it.
Is there anything else you'd like the court to know as far as your goals for you being on probation?
I'm really trying to live cleaner and healthier, and I'm trying to be back with my son. And I'm ready for something different, and I know that I can do it. I know I messed up, but I think if I was given the opportunity, I could really do it.
Okay. Thank you. I'll pass the witness, Your Honor.
All right. State may cross-examine.
Ms. Blackwelder, you said that you had just completed treatment somewhere, is that correct?
Yes, ma'am.
Where was that?
Jackson, Tennessee.
And what was the program?
Jacoa,
And how long of a program was that?
30 days.
And when did you complete it?
in August, and then I went to an Oxford house.
And where's Oxford House?
It was in Madison, it was in Jackson.
Did your probation officer know you were going to all these places?
Well, I was also on probation in Williamson County, and so they sent me there. And so when I got there, I tried contacting her, but I couldn't get a hold of her.
So are you currently still on probation in Williamson County?
No, ma'am, I flattened that.
You flattened that sentence?
Yes, ma'am.
What was that for?
1129 misdemeanor probation for simple possession. I'd been on that probation for a while.
Okay. And you're saying that you completed this in August, is that right?
Yes, ma'am.
Why do you want to go to treatment again?
I don't want to go to treatment, like the rehab. It's just a sober living house.
Okay.
And I think that it would help me keep me on the right track. And they help you get to and from work, so I can save up to get my license back. And it's close to my family because my family lives in Ashland City, so.
Did you say it was in Charlotte?
Yes, ma'am.
Okay. Where is it in Charlotte?
I'm not just sure the exact address, but I think it's over by the Amish store.
Okay.
It's on Old Charlotte, I think, Old Charlotte Road.
So you admit, obviously, that you just recently got 3 new convictions, is that correct?
Yes, ma'am.
The theft, the simple possession, and drug paraphernalia.
Yes, ma'am.
And what was the drug that you were in possession of?
They said that it was fentanyl, but it wasn't my possession. I didn't have it. It was just in the front seat of the vehicle so the dude that was in the car, the truck, he ran and he ran over the median and ran through all the traffic and everything. I wasn't in the vehicle, but my phone was in the front seat when he took off. And so because my phone was in the front seat, they said that I was in the front seat, and so they charged me with it, but it wasn't mine.
But the fentanyl was found in the front seat where your phone was, right?
It was in the floorboard, I guess.
Okay. And you were charged with another charge in Hickman County, is that correct?
Back in April of last year.
Don't tell me about it, because is it still pending?
Yes, ma'am. They won't come get me. I've written
Okay.
out to them 5 times, and my mom called up there too, and they said that they don't transport anymore.
Okay. But you have a current pending charge in Hickman County, right? For simple possession?
Yes, ma'am.
Okay. And you didn't report that charge to your probation officer, did you?
No, I did not.
And
Because I hadn't been convicted on it, so I didn't know that I was.
She's only admitted the violation as to the new charges. That's the basis for her violation.
And Judge, I'm not asking about the details of her crime, only about whether or not she was charged with it.
Well,
And then obviously about another basis of the other charge, I feel is
so if
appropriate.
I'm understanding, there is a pending charge in Dixon County,
In
Tennessee?
Hickman,
Hickman County.
And that, Your Honor, is the basis, is the basis of her other, the other alleged violation in this case, and that's not what she's admitted.
Well, I think, again, she's admitted her violation. It's just a question of disposition. If it's still pending, what may or may not happen. So I'm going to overrule the objection, but she cannot be asked about the details of the crime.
yes,
But
Judge.
I think the question of whether it is pending or not is relevant.
Yes, Your Honor.
Ms. Blackwelder, have you ever refused to appear for a drug screen?
No, I have, it says I didn't show up for the drug screen, but I never got a phone call, or I would have showed up, because I haven't failed a drug test since I've been on probation.
Okay, but you were using drugs, correct?
Again, I would object to this on the same basis, Your Honor. That's the alleged violation in the initially filed warrant.
Judge, I don't think it is an issue whether or not I can ask questions of this witness in regards to whether or not she admitted to that violation or not. It's still a relevant question.
Even if well, number one, if she's admitted the violation, then she's more or less admitted that she was charged with violating her probation, and she's admitted that. And if she is asking for a disposition, then the question of whether or not she is or is not using drugs or has not used drugs is relevant. So overrule the objection.
Yes, sir.
So you said you never tested positive on a drug screen, but were you using drugs?
I smoke marijuana sometimes, yes, ma'am.
And that's why you went to rehab?
Yes, ma'am.
Okay. I don't have any further questions.
I have no redirect, Your Honor.
So you're saying that there is a sober living house in Charlotte, Tennessee?
Yes, sir. Yes, sir. It's
And you're
on,
saying it's somewhere near the Mennonite store, Country View,
I believe so. I believe it's on Old Charlotte Pike.
but you've not ever been there?
No, sir. But I have a bed there.
You have a bed there?
Yes, sir.
And you have any documentation about that? Anything that, in writing, that says you actually have what this place is and what kind of reservation you have?
It's called Archangels. I was supposed to meet with the case manager yesterday at the jail, but she never came and got me, so I don't have anything with me.
Step down. Have a seat by your lawyer. Mr. Talbot, do you have anything else?
No, sir.
Defense is rested. Do the state wish to call any witnesses? Officer. All right, at the jail, what is your name, please?
Yes, Green.
Is that your client as well, Mr.
It
Flanagan?
is, Judge, and we are not ready to set it for trial yet. That's General Sylvie's case, so we need another status date.
Let's go September 23rd. All right, next status will be September the 23rd. Let your lawyer continue to try to work on your case.
I'll be up to see you, Chad.
All right, anything about a bond?
Well, that's what I'm gonna come talk to you about.
Okay,
Okay.
thank you.
And we're waiting on Rebecca Mines.
Judge, on Mr. Bradford's, we're still in discussion about his case, and we're just going to ask to second call it if possible.
All right, we'll put it on the second call. Bring us out another one. Ryan Carmona. Mr. Atchison, are you ready on Brian Carmona?
Judge, I'm going to pass forward Mr. Carmona's plea petition as it relates to his VOP. And
Right. Shows that he is going to admit his violation of probation, waive the hearing, and be sentenced to serve his sentence with credit for time served.
that's correct, Judge.
All right. Mr. Carmona, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Brian Jesus Carmona.
Mr. Carmona, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove to the legal standard that you had violated your probation?
Yeah.
You understand you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes.
Do you understand that if you went to that hearing and I found you guilty, you could appeal what I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're going to be waiving your right to the hearing and to the appeal. All I'm going to do is revoke you to serve your sentence with credit for all your time.
Yes, sir.
You understand everything I've explained to you?
Yeah.
Do you want to plead guilty according to that understanding?
Yes.
And upon your plea of guilty, I order that you be revoked to serve your sentence with credit for all your time, and your lawyer has set forth all of the days that you're entitled to on this document, okay?
Yes, sir.
All right, thank you, Mr.
Thank you,
Atchison.
Judge. I'll get it to you as soon as they get it hooked up.
Have we heard from Crystal Wilkerson before we bring out Derek Dillard?
I believe they're back there speaking with him.
State your full name for the record.
Rebecca Ann Miles.
Ms. Miles, you're here on a multi-count indictment in docket number 2025 CR 59, and then you're also here in 2025 CR 294 on a charge of domestic assault. It's been indicated that you want to enter a plea of no contest to 4 of the counts in the first indictment, and that the second one will be dismissed as a part of that along with the other counts. Have you seen or been shown a copy of those charges, talked them over with Mr. Flanagan and you, and he discussed the range of punishments you're facing as well as possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of no, would you mute the jail for me, please? Well, it's indicated you want to enter a plea of no contest or nolo contendere. All that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result of that, the state will tell me what their evidence would be at trial, and I will use that evidence to find you guilty according to this agreement. You understand that?
Yes, Your Honor.
Understand that you have a right, however, to plead not guilty and to all charges and to have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, Your Honor.
Do you understand that trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial, you and Mr. Flanagan could confront and cross-examine every witness the state calls to testify against you, and you can bring in your own witnesses by using a subpoena?
Yes, Your Honor.
At trial, you would be presumed to be innocent. You would not have to testify or prove anything. Do you understand that there no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering a plea of no contest to these 4 counts, you're waiving your right to contest your guilt or innocence on those charges?
Yes, Your Honor.
You understand that that's going to result in 4 felony convictions, or 4 convictions, and I think it would be all, one's a misdemeanor, and that at that point in time, we will then be setting a sentencing hearing for the court for me to determine what your sentence would be.
Yes,
You
Your Honor.
understand that?
Yes.
Do you understand that while you're waiving your right to contest your guilt or innocence to those 4 counts, you're preserving your right to appeal whatever I did in a sentencing hearing?
Yes,
Do you
sir.
understand that? Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to plead no contest according to this agreement and waive your right to a hearing?
Yes, sir, I do.
Are you satisfied with your attorney's? Well, first of all, let me ask this. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that there are facts to support a finding of guilt in your case?
Yes.
Then I need you to listen as the state tells me what their evidence would be if this case went to trial. If you'll step aside for just a moment, let the state come up to the podium.
Your Honor, if this were to proceed forward to trial, the state would intend to show that on or around January the 22nd of 2025, Ms. Sanders was operating a school bus for Nashville Christian. On the school bus was a 6-year-old with the initials KO. They were going down Highway 70 and were going to turn left onto Highway 96 in the left turn lane. The state would intend to show a witness coming from Highway 70 going towards Dixon before approaching the intersection, observed a red car being operated in a dangerous manner. Then when going around the curve, this red car ultimately struck the school bus, causing it to ignite and catch fire. The driver, Ms. Sanders, and the 6-year-old had to get off the bus and run up the hill to the nearby church for safety reasons. At that point, whenever officers arrived and on body camera, the bus is fully engulfed in flames. This did place Ms. Sanders and the 6-year-old at risk of serious injury. On scene, Ms. Miles had a gash on her head, but ultimately when Sergeant Deloach went to speak with her, he noticed a strong smell of alcohol from her. A blood vial was ultimately collected, showing her to have a .113 BAC. On top of mixing that with her oxymorphone, 9 nanograms of that as well mixed with it, which TBI would say would have a synergistic effect, ultimately enhancing the effects of each other, not simply 1 + 1. Inside of her purse, Ms. Miles did have a prescription for the oxymorphone, as well as a handgun. Ms. Miles is a convicted felon, and she has ultimately previously been convicted for aggravated assault, which would make this a Class B felony. This is notated on the plea petition. For Your Honor, ultimately, with the sentencing hearing, we'll be looking at 8 to 12 years, which will be the manner of service, and ultimately the length will be decided by Your Honor. As required under TCA 40-35-501, Both the child endangerment as well as the felon in possession of the firearm are 100% offenses. That is notated on the plea petition. Those are the facts that the state would intend to show for purposes of the DUI with the .113 and the oxymorphone, the reckless endangerment of the bus driver, the child endangerment of KO, and the possession of a weapon by a convicted felon. Thank you.
All right, Ms. Miles, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes, Your
You
Honor.
still wish to plead no contest.
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel that Mr. Flanagan's done a good job of representing you competently?
Yes, Your Honor.
Mr. Flanagan, you know of any reason she should not enter these pleas?
No.
And we need to go ahead then and set a sentencing hearing. I do find that she is guilty in count 2 of driving under the influence of an intoxicant. Count 4, I found her guilty of reckless endangerment with a deadly weapon. Count 6, I found her guilty of child endangerment of a child less than 8 years of age. And count 8, I found her guilty of being a felon in possession of a firearm. We will then set a sentencing hearing. I assume that September would probably be as early as we can get that done.
We could, if you would allow.
July. My criminal docket is on the 14th of July. VOP day would be 28th. We can set it at 1 o'clock on the 28th of July.
Please, because I'll be in trial on homicide.
Is the 28th okay? All right. Mr. Flanagan, is that all right for you?
It is, Judge.
We'll set it at let's do it at 1:30 just to be safe, but 1:30. We need a pre-sentence report, yes. July this 28th. Right. All right.
Okay.
All right, at the jail is, are you Ronnie McCoy? You're muted. You'll have to unmute that device.
Yes, Your Honor, I was, Brian McCoy.
All right, Mr. McCoy, your lawyer has asked that you be brought down, so we're going to bring you down so that you can hopefully dispose of this case, all right?
Okay, thank you.
Thank you.
Thank you, Judge.
Next up, I've got Tanner Bishop.
All right, you need to talk to Mr. Bishop. All right, we'll put it on the second call. You have another one, Sergeant?
Bring out Jason.
All right, bring him out, please. Yes.
Mr. Bishop is going to get a trial date on that helps the deputies if they can take him back. So,
All right, and we don't need Mr. Tyner Bishop brought out?
no, we don't. I've told him what we're doing. That's General Bryson's.
Right. Well, let's just go ahead, before we start this hearing, let's go ahead and set a trial date. You're wanting a trial date on the sex offender registry violation form, correct?
Yes.
State have a date in mind that you want to try Mr. Tyner Bishop on that charge? Probably looking at January.
Judge, I don't have your trial dates
marked, so I think it's a one-day trial.
What about, is it one-day trial,
Yes,
Could be
Judge.
half a day. I think it's going to be non-jury.
January 15th?
That's fine, Judge.
January 15th. The OP will be moved to January 27th.
Thank you, Judge.
All right, we're back on Cordarius Godwin. Defendant's motion to reinstate bond.
Outset, we have an order for expungement for the case that was tried in January and February. And I'll call Mr. Godwin briefly, Your Honor, but just to go over some of the things in the motion. Could you state your name for the record, please?
Cordarius Godwin,
Okay. And Mr. Godwin, where are you currently being housed?
Dixon County Jail,
Okay. And how long have you been there?
2.5 years.
Okay. Did you do some time before that on this case?
Yes.
Okay. And now, was some of that time at the outset of the case where there was a capias issued for a failure to appear? Okay. And did we have a motion to reinstate your bond based on that being a communication error with Ms. Fordyce?
Yes, sir.
Okay. And was your bond reinstated based on that hearing?
Yes, sir.
Okay. Have you ever had any other failures to appear?
No, sir.
Okay. And were the charges against you in Lawrenceburg, were those dismissed?
Yes, sir.
Okay. And if you were released, where would you be living?
Lawrenceburg, Tennessee.
Okay. And is that an apartment?
Mm-hmm.
Okay. And did you live in Lawrenceburg while this case has been pending when you were on release?
Mm-hmm. Yes.
Did you fail to appear at any time for that?
No, sir.
For any of these hearings?
No.
Okay. Would you be willing to wear an ankle monitor if you were released, if the court required that?
Yes, sir.
Okay. And any other conditions, would you comply with those?
Yes, sir.
Okay. And do you have other family in the Lawrenceburg area?
No, sir.
Okay. Do you have other family in the Middle Tennessee area?
Mm-hmm.
Okay. And who are some of those?
And Nataska Godwin,
Okay. And where does she live?
Murfreesboro.
Did you stay in contact with her often?
Mm-hmm.
Is she in the courtroom today?
Yes, sir.
Okay. And how much bond could you afford if you were released?
I don't know.
Okay. Did you work while you were out?
Yes, sir.
Okay. What type of work did you do?
Cabinet installation.
Cabinet installation?
Mm-hmm.
Did you work at some restaurants?
Mm-hmm. I worked at Chili's.
At Chili's? And did you work at Applebee's?
Mm-hmm.
And you've stayed in contact with me anytime you've been out?
Yes, sir.
Okay. Would you continue to stay in contact with me?
Yes, sir.
Okay. Those are my questions, Your Honor.
General Bryson?
Mr. Godwin, you have a pretty lengthy criminal history, is that right?
Yeah, mostly from a juvenile.
Okay. When did you get your first criminal offense?
2007.
Okay. And that would be when you got your robbery, ag burglary, a second robbery, an aggravated kidnapping, a theft of property, and an especially aggravated burglary, an aggravated robbery, an aggravated kidnapping, and a carjacking. You got all of those in 2007, is that right?
Yeah, it says a juvenile.
And you were transferred to adult court?
Yes.
Have you ever failed to appear for a court date other than the one where there was a mix-up with Miss Fordyce?
No,
Are you sure?
I can remember.
So you don't remember failing to appear in 2017 or driving on revoked here in Dixon County?
No, ma'am.
You don't remember pleading guilty to that, to a contempt of court in 2018?
No, ma'am.
So do you think, if your criminal history shows that, is it wrong or you just don't remember? No, different question.
It's a different question, overruled.
So are you saying if your criminal history shows that it's wrong or you don't remember?
I just don't remember that one.
Do you think your behavior in the jail has been good?
Yes, I'm in the honor pod.
Have you had any jail write-ups during your time?
Yes.
What have you been written up for in the jail?
Destruction of county property.
What did that involve?
I broke a visitation handpiece
Is that your only write-up in the jail?
that I was charged and found guilty of, yes.
Have you been written up for other things that you weren't found guilty of?
Yes.
What else were you written up for?
For letting somebody use my phone PIN number, but it was a mix-up.
Have you, during your time in the jail, have you ever had your phone privileges suspended?
No.
Where did you say you intend to work if you get out?
Well, I'm starting to go back to CDL school.
CDL school?
Yes, ma'am.
And where will that be?
Columbia.
Is that something you have to apply for?
I already started the application process.
Okay. So have you turned in that application?
Yes.
And when will you hear back on if you've been accepted?
I don't know yet. It's still in progress.
The place that you're going to live, will that be with other people?
Yes.
Who else will be living in that house?
Emily McCall,
Okay. Who is Emily McCall?
my girlfriend.
Does she have kids?
No.
Will anyone else be in the house?
No.
During your time in jail, have you maintained communication with Miss McCall?
Yes, ma'am.
Okay. Have her calling privileges ever been suspended to you?
No.
Are you sure?
Yes.
So you don't remember when her call privileges, her video call privileges were suspended?
Yeah, her visitation was.
Okay, why was her visitation suspended?
I don't remember.
Could it have been because of sex acts on those phone visitation?
Maybe yes.
A sex act? Is
Yes,
this a
Judge.
video call from the jail? Is that
Yes,
correct?
Judge. So you don't remember or you don't want to say?
No, I said it could have been
It could have
sexual
been.
conversations.
Nothing further, Judge.
Mr. Spratt, do you have any redirect?
About 5 years.
5 years. And you've done how long in jail? You said 2.5 years this time. Do you know how much you did up front?
Up front, about 11 months, almost a year.
So almost 3.5 years
Yes,
on these charges.
yes.
And you were not, okay, those are my questions.
Anything further from the state? Thank you, sir. You may step down and have a seat by your lawyer. Mr. Spratt, you may call your next witness. Excuse me, the defendant has rested their proof. State, have any witnesses you wish to call? I'll hear you in argument.
Godwin has done some 3.5 years. There are 3 cases remaining, one of which is a vandalism, one of which is an E felony, and then there is another B felony pending. 2 of those were, as I said, were indicted, not at the exact same time, but they were not committed or alleged to have been committed while he was out on bond. He's done, as I said, 3.5 years. His bond's been revoked on these charges. First basis was dismissed. In Lawrenceburg, the first case tried was not guilty by jury verdict. And he's yet to cross-examine a witness about any of the basis for any of this revocation. So he's not, I would reassert that I don't think he's had a meaningful Bergens hearing yet as to why he can't be on bond. As to the failure to appear, that was an error that we sorted out upon my appointment of the case. So he's testified that he would be willing to comply with an ankle monitor and show up to court. And he has stayed in contact with me throughout the pendency of these cases. So we're just asking that the court either reinstate the reasonable bond or understanding the serious nature of the charges, he does carry the presumption of innocence. And so we ask that based on all of the factors, that the court set bond at $50,000 aggregate to assure Mr. Godwin's appearance at the future proceedings with the condition of an ankle monitor and any such other conditions.
General Bryson.
Judge, this bond was appropriately revoked. Originally, this court has already entertained and heard one motion to reinstate this bond, which it denied in December of 2024 and entered that order. The defendant on this case has a criminal history that ranges him to a career offender. On that B felony, that means he faces 30 years if convicted. The court has had an opportunity through its interaction with this case, through the file that's in front of it, to be both aware of Mr. Godwin's criminal history and other conduct. Judge, if the defendant was granted bond, which I think the bond revocation is appropriate and should stay, if the defendant is granted bond, not only should he have an ankle monitor, he should not be allowed around any business that serves alcohol. Judge, the court is well aware of the nature of the defendant's cases and that he is a danger to the public. With his prior history, with the attaining of new charges, regardless of their disposition, the bond revocation is appropriate. The state would ask for an extremely high bond if he was granted a bond, as well as conditions tailored to keep the public safe.
The state sought the revocation of the defendant's bond pursuant to 40-11-141. Subsection B of that statute says the following: if after the defendant is released upon personal recognizance, an unsecured personal appearance bond or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond in order that the defendant be held without bail pending trial or without release during the trial. And is note that the court notes that it is not required that the defendant be convicted of those charges that occurred during his release from jail, only that he be charged. Clearly, the state's motion to revoke his bond initially was based upon not just the charge that he went to trial on. Instead, it was based upon the fact that there were a number of charges, including the ones that later got dismissed in Lewis County. And this court is of the opinion that the state's motion was well taken at the time. Revoke that bond based on that fact. Now the defendant comes back in asking again to be reinstated to bond simply because he stood trial and was acquitted on the one charge. But he is presently facing a charge of Class B felony rape in docket number 192. 2020 CR 351, and then vandalism, which is a Class E felony in the other case, which is 2021 CR 59. The state has filed an amended notice of impeachment and range of punishment. And I think it's instructive to review that. He was found guilty in Circuit Court of Madison County, received a 6-year sentence for a Class C felony of robbery. He was found guilty, and that was in 2007. In 2007, he was also found guilty of aggravated burglary, a Class C felony, and sentenced to 6 years. He was found guilty in that same time period of robbery, Class C felony, and received a 6-year sentence as well. 2007, again, he was found guilty of aggravated kidnapping, a B felony, received a sentence of 8 years, 2009 in Madison County. He was found guilty in Madison County in 2007 of theft of property, $1,000 to $10,000, a D felony, received a sentence of 4 years. He was found guilty in Madison County in 2007 of especially aggravated burglary, a B felony, received a sentence of 10 years. He was found guilty in Madison County of aggravated robbery, a B felony, sentenced to 10 years, and that's also in 2007. He was also found guilty in Circuit Court of Madison County of aggravated kidnapping, a B felony, received a sentence of 10 years. He was found guilty in Madison County of carjacking, a B felony, received a sentence of 10 years. All of those offenses are felonies that will bump the range of punishment up to a career offender. And so, as correctly was pointed out, the defendant is facing a substantial sentence if he is found guilty of either one of these charges, actually, but certainly of the Class B felony. And in this case, he is charged with sexual battery and vandalism. So in docket number 192, which is the case that is pending, he is charged with sexual battery without consent which is a Class E felony, is also a Class A misdemeanor. So he has another charge of rape, another charge of sexual battery without consent, and then a couple of misdemeanors. This court is of the opinion that the court acted correctly in revoking his bond to begin with, and I find that simply because of the charges that, and the nature of the charges, and the fact that there is substantial sentence awaiting Mr. Godwin if he is convicted, that the revocation of his bond should remain in place, and I therefore deny your motion to reinstate. We're going to take a 15-minute recess.
Thank you, Your Honor. Good morning. This is Mr. Jonah Allen. His case is set for a probation violation hearing today. He's got a case in Hickman County that's in bindover. We'd ask to reset this to the September VOP date, please.
What is that day? I could look on my own calendar. All right, reset for September 30th.
Thank you, Your Honor.
Do we have inmates up here already? All right. 2025 CR 162, State versus Christopher Aaron Carson. This is apparently the attorney is Sunny Stevens. She's running late. She had to be somewhere else.
I'm confused, because I have Mr. Carson, but his case is actually on the June docket, is what I was tracking. Is Ms. Stevens also, or has she been retained?
What is that about?
She represents the bond.
Oh, okay. Got it. Well, we have him, when she arrives, we'll deal with it, but. (2022) CR 468, State versus Tyler J. Chambers. Tyler Chambers for violation of probation hearing.
Your Honor, Mr. Chambers has some pending charges. I think we've got him set on the new charges in September, Your Honor. I think that's is it the 23rd date? I think September 23, Your Honor, is the date we have the other charges set. My thought is if we can put this VOP on the same day as those other charges, we can get them all.
So do you want to put it on September the 23rd or the 30th, which is VOP day?
Thank you, Your Honor. September 23, please.
September 23.
Your Honor, I apologize. May we please have September 8 to put all of his cases together?
All right, September the 8th instead of the 23rd.
Thank you, Your Honor.
All right. Do we know if Mr. Chambers is in custody somewhere else? And do we have, excuse me, do we have any of these people that are here on Zoom for the jail? Okay. When you have inmates arrive, let me know and we'll take them up. We'll move to page 5, 2026 CR 148, State versus Ray Osro Dorman.
Your Honor, Mr. Dorman is also in custody, I believe. His is a plea by information, so once he arrives, we'll be ready to take that up, Your Honor.
He's in Dixon Jail?
Yes, sir, he is.
Okay. If you will add him to the list, please. 2025 CR 256, State versus Rodrigo Flores. Mr. Baker's case.
All right, I haven't seen Mr. Baker yet. That was one where we were wanting to see about if we were going to reach a settlement agreement today or not, so I would ask the second call it.
Put it on the second call.
Yes, sir.
2024 CR 192, State versus Danielle Lee Spicer Generizio. Restitution hearing.
Yes, Your Honor. General Wodnarowski and I have settled that. We're going to submit an agreed
All
order
right.
to
An agreed
resolve
order
that.
will be submitted.
Thank you, Your Honor.
Thank
And
you.
Ms. Generazio is present. May she leave, Your Honor?
She can leave. All right. 2024 CR 242, State versus Ryan Hale Sr. Mr. Talbot's motion to sever defendants.
Judge, the co-defendant pled last court date, so I'd say the motion to sever is moot at this point.
We will,
I'd like to get another status date, but Mr. Talbot may want to be here for that.
well, as soon as Mr. Talbot comes back in, we'll take it back up. Have a seat. 2022 CR 26, State versus Sabrina Ann Hipshire. This is the public defender.
Judge, on Ms. Hipshire's case, she has a violation of probation. To resolve this, she is going to admit the violation of probation. She'll waive her hearing. She'll be reinstated to supervised probation with in-person reporting only. And she has, I've reviewed this with her. You can date there and sign there for this position. Today's the 27th of May. All right, thank you. Thank you.
Ms. Hipshire, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Sabrina Ann Hipshire?
Ms. Hipshire, you're here on a violation of probation. You have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation. Do you understand that?
Yes.
Do you understand you would have the right to have a lawyer and have one appointed if you could not afford your own, as we've done with the public defender?
Yes.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by pleading guilty, you're waiving that hearing and you're waiving the right to appeal?
Yes.
You understand I'm going to approve what your lawyer and the state have agreed upon, which is to reinstate you to probation, but you're going to be required to do in-person reporting only, and this is your one last chance to successfully complete your probation. Do you understand
Yes.
that? You understand everything I've explained to you?
Yes, sir.
Do you wish to plead guilty according to this agreement?
Yes.
And upon your plea of guilty to violation of your probation, I find that you should be revoked to serve your sentence. However, by agreement with the state and your lawyer, I will reinstate you to supervised probation, but require that you be in-person reporting only. Make sure you know who your probation officer is and stay with them, okay?
Yes, sir. Thank you.
2024, Mr. Talbot, I had a Ryan Hale Sr., and it was your motion to sever defendants, but General tells me that the defendant, co-defendant pled the other day, so it renders your motion to sever defendants moot, I would think.
It does.
All right. Do we have a status day on it?
I think that we had one earlier this month, Your Honor, and the case was reset to today. So if we can go to the status
September
date,
8th.
September. Thank you, Your Honor.
That'll be the final status day. You can either plead that day or go set a trial date. So.
Yes, Your Honor.
2024 CR 247, State versus Dalton Ray Hooper. That's Mr. Flanagan's case. Anybody heard from him today? Is what?
I think he's just shocked you're on time.
Normally you were up and moving around a little bit. I just wasn't sure. So that's what I was afraid of. All right, we'll put it on the second call. You need to be a little bit more assertive in your old age. So 2023 CR 169 State versus Jeremy J. Jaco. Mr. Sanders. Anybody heard from Mr. Sanders? He's not in the box, right? Put it on the second call. Twenty 131 State versus Kevin Nilish Kesaria. It's the Hall Brothers Bonding Company's petition for extension of a final bond forfeiture. Anyone here from Hall Bonding Company? Hall Brothers Bonding? I don't know. Scott Hall. Just move this to, he hasn't appeared. In my opinion, if he wants an extension, he needs to appear. Just put it on the next criminal docket call for whoever the next judge is. Let him know he needs to be here to argue it. 2020 CR 185 State versus Stephen P. Lane. Mr. Bell Myers.
Judge, I actually spoke to Mr. Belmars and then also have been speaking to Mr. Baker, who's been speaking to Mr. Lane. We're close to a resolution on the criminal case as well as a civil case, and we asked to put it on June 15th for status.
June 15th?
Yes, Judge.
All right. So
I think that's
15th.
Judge Wallace's bail day.
All right. June 15th. On page 14. Well, we can put it on June 15th, but it's because Mr. Lane, it's a motion for new trial, which I heard the trial, so I would have to hear the motion for new trial.
Home improvement / theft case in which you granted
That's true.
one. So
Since I
we're-
granted a motion for new trial, then we start over from scratch.
And I think it's just a date so we can at least make a resolution, Judge.
All right, that's fine. 2024 CR 100 State versus Natasha Nicole Smith McCoy. Mr. Spratt.
Robertson County, there was no hold placed on her based on your Honor's order. But we did enter an agreed order for her to go into custody. I have not spoken with her in about a week.
So she's supposed to be here today or be in custody, is that correct?
Supposed to be in custody. You revoked her bond.
Will we have a capias out there for her then?
It's taken into custody that day. Robertson County on a violation of probation.
Issue a capias for her. Hold for hearing. (2024) CR 67 State versus Charles McDonald, Mr. Wainick's case. Let me guess, he's at court somewhere else. Anybody heard from Mr. Wainick? We'll put him on the second call. 2022 CR 379, State versus Kevin James Moran. Mr. Flanagan.
Money. I haven't heard from him forever, so.
April the 17th, he announced.
Oh, okay. Not good taste, if nothing else.
All right, Mr. Moran is not here. Mr. Flanagan, you've obviously not been hired to represent him. Issue a capias for Mr. Moran to hold for hearing.
I'm gonna try to call him on the break.
Do you know him? All right, well, we're going to still stand on the capias. Yes. So has he got a bond? A release on recognizance. So that's revoked. Issue a capias. All right. 2021 CR 365, State versus Joey Adarez Nixon. This is for payment status.
$9,000.
I do have an amended violation of probation warrant that was issued on May 14th of this year. Mr. Nixon, it's alleged on this amended violation that you were convicted of theft on or about the 18th day of November 2022 and sentenced to 2 years in Tennessee Department of Corrections. It is alleged that you have violated Rule 1 in that you were arrested in Williamson County and charged with unlawful carrying or possession of a weapon and shoplifting or theft of property. And that also violates Rule 3 of your probation. Because of this, you have the right to have an attorney represent you, because if those are the facts, then you very well may be looking at your sentence being revoked. Do you wish to have a lawyer represent you?
I do.
Are you planning to hire a lawyer of your own?
Yes, sir.
All right. What is the June VOP day? All right. You'll be served with this amended violation of probation. There's a bond of $2,500 that you'll be required to make. That's, I judge whoever that was that issued the warrant. I can't read his signature. Is that Turnbow? Judge Turnbow has set a bond of $2,500, so you'll be in custody until you make that bond.
I've already did that, Your Honor.
You've already done that?
Yes, sir.
Good. We'll see you on June what? June 29th is when you need to be back with your lawyer.
Okay.
All right, thank you.
Thank you.
Show he's been arraigned, give him a copy. Mr. Nixon, let's give you a copy of this new amended warrant if you don't already have one. And you need to give that to your lawyer that you hire. All right, well, that's a copy he can have. All right, that's fine. He has a bond, so he'll be released. 2024 CR 67, State versus Anthony Nathaniel Thompson. Mr. Webb's case. We get a new trial date. This is on the conspiracy of possession of methamphetamine over 300 grams. Is this one of the ones that we already have a trial date on? Mr. Talbot?
Thank you, Your Honor. This is Ms. Tiara Bethke. She's here on a probation violation. There's been some negotiation. I have one settlement offer that I'd like to discuss with her, so if we may second call this, I'd like to meet with her.
All
and
right,
see if
I'll
we
put
get
it on
this
second
resolved.
call.
Thank you, Your Honor.
Okay, what do you have, Mr. Flanagan?
Judge, on Dalton Hooper, if we could have one more status date, he's here before we set it for trial.
On page 9, you want to set it for September the 23rd?
Yes, please.
September 23rd will be the final status day.
Thank you, Judge.
Okay, we ready for inmates? Bring out the first one. We bringing out the inmates? Okay.
Pages 9 through 11. What we would like to do is go ahead and have Mr. Jackson admit the violation, but have a hearing on disposition.
All right. State your full name for the record.
I can't tell Rashad Jackson.
Mr. Jackson, you're here today on violation of probation on a number of different indictments, but you have, you understand that you have the right to plead not guilty to that and have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation. You understand that if you had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with the public defender.
Yes, sir.
You understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with the appeal. You understand that by pleading guilty to the violation, you are actually waiving your right to the hearing as to whether or not you did or did not violate your probation. But you are preserving your right to appeal whatever I do at a sentencing hearing on that. Do you understand that? You understand everything I've explained to you? Do you want to admit your violation and go to a disposition hearing?
Sir.
All right, then I find you're in violation of your probation and we'll have a hearing. So Howard, you ready to put on your proof?
Yes, sir. If we could call Mr. Jackson.
Mr. Jackson, if you'll step around here, please.
So, Mr. Jackson, this violation is based off of some new charges that occurred here in Dixon County. Is that correct?
Yes, sir.
And you've resolved those charges?
Yes, sir.
When were those resolved?
I forgot the day.
Well, we don't need the exact date. Would you estimate a couple weeks, a month?
A month ago.
Month. And what happened with those charges?
I had 3 ran concurrent with my 8.
Okay, so you pled guilty to those charges?
Yes, sir, with lesser charges.
Sure. But you didn't contest them, and you're
No,
not
sir.
contesting this violation?
No, sir.
Okay. And prior to that, you were in the drug court here in Dixon County, right?
Yes, sir.
How long were you in that program?
2 years.
And what was the outcome of that program for you?
Graduated.
How were you doing while you were being supervised by them? Tell me about life.
It was good. Right.
What about after you graduated the program? What happened? How did you get off track?
Less structure.
Yeah? You fall in with the wrong crowd?
Yes, sir.
All right. What do you think would have prevented that?
Should have went over to the halfway house program of drug court.
Was that a voluntary decision on your part not to do that?
Yes, sir.
Okay. Regretting that decision now?
Yes, sir.
All right. What is it that you want to be the outcome of this proceeding here?
Looking for community corrections. Add a year on my 8, moving to community corrections.
Okay, so you're just seeking more structure in that regard?
Yes, sir.
All right. I'll pass the witness at this time, Your Honor.
Mr. Jackson, you were on probation for theft, aggravated burglary, false reports, burglary ×3, and failure to appear. Is that correct?
Yes, ma'am.
And you've had a prior violation of probation hearing.
I don't recall.
You don't remember being violated before, and that's what sent you to drug court?
Ma'am, I went to Clarksville jail, and then somehow Dixon got me back, but I didn't. I was on probation at Clarksville, and my PO said that she wouldn't violate me because I got arrested right in front of her.
So you don't recall a violation hearing in which you got sent to drug court?
No, ma'am.
All right. And then, when did you graduate from drug court?
December 28, 2025.
And you admitted that by February, you had absconded from your probation. Is that
Yes, ma'am.
correct?
Yes, ma'am.
You had quit your job or was terminated for basically not showing up at Nashville Wire. Is that correct?
Yes, ma'am. Got another job.
And you, in February, before you absconded, you tested positive for cocaine.
Yes, ma'am.
And this is all within less than 2 months of you completing drug court.
Yes, ma'am.
You also, in April, got charged with domestic assault ×2, aggravated assault, interference with an emergency call, and aggravated burglary of a habitation. Is that correct?
Yes, ma'am.
And then you've pled guilty, you said, to 3 of those counts,
Yes, ma'am.
and were given misdemeanor sentences.
Yes, ma'am. For lesser charges.
Okay. And the offense of, let's see. Who was the victim of the domestic assault?
Tierra Bethke.
She's here today too, it looks like, I think. Do you know that?
Oh, ma'am.
Okay. Was Tierra Bethke in drug court as well?
Yes, ma'am.
And she had graduated around the same time?
No.
Thank you, I don't have any further questions.
Redirect.
Okay, so I think we're getting confused about some things, Mr. Jackson. So you were on probation in Dixon County, right?
I was on probation in Clarksville, Tennessee.
There's an old Dixon County case that you had a probated sentence for. I understand you were reporting in Clarksville, but you have some old Dixon County cases you were on probation for, correct?
Yes, sir.
All right, and then you got arrested in Clarksville, you said.
Yes, sir.
And you were of the understanding that your probation in Dixon County wouldn't be violated for that.
Yes, sir. I got arrested right in front of my PO, and she told me that I'm not violating you. And then I went and did the 3-in-1, and then I served a year, and then Dixon came and got me.
Yeah, because there was a violation pending for you.
Okay, yes,
You
sir.
may not have understood that,
Yes,
but,
sir.
all right. And then another thing, so you said that you graduated from court on, a recovery court on December the 28th.
Yes, sir.
But there is an order in your file from February the 9th that was reinstating you to probation. What happened between December 28th and February 9th? Were you still reporting to drug court? Or did you just know you had a court date in the future?
I went to, it was the previous Monday or something that I had to go report to Mr. Fry for my intake, and then I started seeing Miss Bright.
Okay, so you were reporting to probation during that time, even though the order reinstating you to probation wasn't entered until the 9th of February?
Yes, sir. I don't know when the intake was, so it was in between those, the time of seeing Miss Bright for the first time, and then that's whenever I was, I guess, initially reinstated.
Okay. And did you let Ms. Bright know in any way, or were you not able to make a phone call once you had the incident that got you arrested?
I never knew about the charges until they came and got me.
Okay, so you didn't have the opportunity to let her?
Yes, yes, sir. I never knew anything about any of the charges.
All right. Nothing further, Your Honor.
Anything further? Thank you, sir. You may step down. Howard, you may call your next witness. Do you have any proof you wish to offer? Officer Bright? Different hearings, so raise your right hand. Let's place you under oath again.
I do.
You are Officer Christina Bright,
Yes,
and were you supervising Akey Jackson?
yes.
Now, when did Mr. Jackson graduate from drug court?
It was the end of December.
Okay. And was he supposed to report during the time period of January?
I had him come in for intake in January.
Okay, so he reported in January,
Correct.
but he was not reinstated to probation until February?
Correct.
At some point in time, Mr. Jackson stopped reporting to well, let me ask you this. February 9th, when he was officially reinstated to probation, is that the day he tested positive for cocaine?
Correct.
Okay. What did you do at that point as his probation officer?
We had several talks, and he did state that he wanted to go to a halfway house because it would be more stable. I talked to him about possibly going back to the drug courthouse, things like that. I don't know that he ever did it, because shortly after he took off.
Okay. Do you recall so February 9th he reported, is that the last date he reported to probation?
I believe so.
How often was he supposed to report to probation after graduation?
He was supposed to be reporting monthly.
And it shows on this, let's see. He failed to report to probation on 2/20 and 2/24/26 on the affidavit, is that correct?
Yes.
Okay. And he obviously hadn't noticed he was supposed to report.
He knew he was supposed to report, yes.
Was he at some point in time found with another drug court graduate?
Him and Tierra Bethke both admitted that they had started a relationship while they were still in drug court.
And is that something that they're allowed to do?
No.
You list in the instructions as well that he was terminated from Nashville Wire.
Correct.
Do you know how long he had been working there?
All throughout drug court, I believe.
Okay. And at some point, he was terminated, looks like, for abandonment. He didn't show up.
Correct.
Do you know where he was during this time he's absconded, or did you find out otherwise?
No.
At some point in time, he was also charged with new offenses.
Correct.
Do you know anything about those new offenses?
There was two, one of them was he broke into the drug courthouse. And then the other one was the domestics and stuff with Miss Bethke, I believe.
And that's the person who had graduated from drug court and they were in a relationship
Correct.
with? Okay. Has Mr. Jackson been violated on probation before?
Yes. That's what put him in drug court.
So this is his second violation on his cases involving theft, aggravated burglary, false reports, burglary ×3, and FTA.
Correct.
Do you have any recommendation to this court in regards to how Mr. Jackson will do on supervision?
I don't think he'll do very well at all.
You have anything else further that the court needs to know about Mr. Jackson?
Other than he didn't do very well from right after graduating drug court, I don't recall any significant mess ups during drug court. He admitted that he was in a relationship that he shouldn't have been in, but other than that, I don't recall or remember any significant ones during drug court, but immediately after, he just went downhill.
Okay. Thank you, Officer Wright.
Mr. Howard?
Officer Bright, could you detail for the court just how involved you are with participants in drug court while they're in the program?
I come to court weekly, or when court's held. I talk to the participants and stuff if the judge isn't in the courtroom at that time, here and there.
So you're fairly familiar, it would be fair to say, with most of the participants?
Correct.
Okay, and when somebody steps out of line, you're aware?
Correct.
Okay, and Mr. Jackson was in for 2 years, right? Thereabouts?
I would say possibly. I don't know the exact dates.
Okay, and you just testified that during that 2-year period being supervised by drug court, you can't recall an occasion he stepped out of line?
Nothing sticks out to me, but again, we have participants coming and going. I would have to look back at the records, the drug court records.
But then almost immediately, as soon as he didn't have that structure, he just goes off the rails.
Right after he graduated, pretty much.
Okay. So you'd agree that structure keeps Mr. Jackson in line?
Sure, if you're going by just drug court and then him getting out, but he chose to leave that environment.
And
He could have stayed.
you'd agree that's a bad decision?
Correct.
And so do you think the structure of community corrections would be a better decision for Mr. Jackson?
No.
Why is that?
Probation and community corrections can be as structured as possible, but if he's not in an environment that holds him accountable like drug court, then I don't think it's going to make a difference.
Nothing further.
Step down. Do you have any other witnesses? Mr. Howard, do you have any other proof? I'll hear you in argument.
Mr. Jackson is no stranger to the court system. He has gone through several periods over the past pushing a decade now, 2019, what is that? That's 7 years thereabouts. He goes through periods where he does well, he walks the straight and narrow, and then he gets in with the wrong people, he falls into making the same bad decisions, he relapses. We see this all the time. Mr. Jackson was the first to admit that he made some bad decisions. You heard from the probation officer that when he was involved in drug court and had the structure of drug court, he made better decisions. And what he's asking the court to do is just give him another chance, put him in community corrections, extend his sentence if the court sees fit, but give him some structure and give him an opportunity to go to a halfway house, to get the support that he needs to continue to succeed. He has a ton of credit, Your Honor. He's been doing this a while and he's just had a slip up. He's asking the court to give him another chance to make it right.
Mr. Jackson has had many opportunities to make things right, Your Honor. He clearly entered a plea in regards to multiple different felony counts, was given an opportunity to be on probation. He violated that probation and was given an opportunity to go to drug court. He went through drug court, which, as this court is well aware, is usually, we consider, the last chance. It's their last chance to get help that they need. Mr. Jackson did complete drug court, but immediately, Judge, he immediately went off the rails, just as soon as he graduated. He absconded, he got new convictions, he broke into the drug courthouse, he tested positive for cocaine, he was terminated from his employment. He just did everything he wasn't supposed to, Judge. He was given an opportunity. Officer Bright testified when he came in on February 9th, and reported and tested positive for cocaine, he was given an opportunity. You can go back to the drug courthouse. He chose not to, and now when he's facing his sentence to serve is when he wants structure. I ask that you revoke him to serve.
Well, the question arises is, there's no doubt that this defendant, Mr. Jackson, apparently did better when he had someone looking over his shoulder, and as was stated, that the structure kept him in line. Question becomes, at what point is society required to provide structure for individuals who willingly prevent or commit new offenses? Mr. Jackson was found guilty of, as the state has pointed out, of theft, aggravated burglary, 3 counts of regular burglary, making a false report, and failure to appear. All of those were combined into an 8-year sentence. And he was placed on probation, given that chance. He violated that probation and appeared in front of Judge Larry Wallace, and Judge Larry Wallace approved him going into the drug court program. And as a condition of that, he was to complete the rehab and the drug court program and be returned to probation. So in February, he was February 25, I guess it was, he was returned to probation. I'm sorry, it's 26. So February of this year, he was reinstated back on probation. And as has been cited by the state, he immediately violated the terms of his probation by not only not reporting, not only testing positive for drugs, but then going out and committing new offenses. So there's no reason this court can find that to believe that if the court returned him to any sort of probation, that he wouldn't go back out and commit new offenses. At this point, as I have to agree with the state, that the drug court program has always been, in this court's opinion, the final last chance for someone to avoid having to serve their sentence. Mr. Jackson had that opportunity. All he had to do is stay out of trouble. And I don't think that he's entitled to a 3rd or 4th chance. So for that reason, I revoke him to serve his sentence. He'll get credit for all the time that he has served. So. Bring out the next inmate. Mr. Sanders, we had Jeremy Jaco that you were representing.
I received a text message yesterday from a acquaintance of my clients indicated that Mr. Jaco had passed away at 2 a.m. yesterday morning. I don't have any official, that startled me when that door opened. But I don't have any official verification of that. I don't have a death report or, anything like that. But the word that I received was that Mr. Jaco had passed away. I do know that he had been battling cancer, very serious matter, and I did have a confirmation that he was receiving hospice care. So all indications would be that that's accurate information, but I'll supply official word.
Just give us some sort of confirmation of that, and that'll be sufficient. Your reaction reminds me of the story that I don't know if it's apocryphal or true, but someone was on trial for murder, and the defense lawyer, the body had never been found. The defense lawyer was arguing that the state hadn't proven that the defendant was actually deceased. And he turns and says, for that matter, he could be walking through the back door right now, and the back door's open, and somebody walks in, and all the jurors look. And the defense lawyer said, the fact that you looked is reasonable doubt. So anyway, I don't think it worked, but whatever.
Well, when that door swung up, it was a moment. It was a moment there, but yes.
All right, let us know when you find confirmation.
Yes, Your Honor, thank you.
Then let's go ahead and bring out that inmate. So. Mr. Talbot, what do we have?
Thank you, Your Honor. This is Mr. Cody Lewis. He's set for a VOP hearing today.
Okay.
Mr. Lewis would like to apply for recovery court. May we please reset this 30 days to the next VOP date?
All right, let's put it on June 29th. Is
I just heard you that.
I just started that.
it? This was just issued this morning, so
Then I'm going to represent.
give this, if you will, please, to Mr. Talbot.
Received, Your Honor. I acknowledge receiving this and waive formal reading of the same and enter a plea of not guilty on behalf of the defendant.
Plea not guilty is entered. We'll set it for the June VOP day, which is June what? June 29th.
June 29. Thank you, Your Honor.
All right. I'm going to go back to page 3, 2025 CR 162, State versus Christopher Aaron Carson. Ms. Stevens, you have a motion for the bonding company in that case? Yes, Your Honor. Let me pull that file. Hold on just a minute. All right, your motion states that the defendant was arrested and charged with being a fugitive from justice and incarcerated in the Sumner County Jail.
Yes, Your Honor.
And then on April the 28th, he was extradited and transported to Berrien County Jail, Berrien County, Georgia. And
Yes.
he remains there on a felony probation violation.
Yes, Judge.
And pursuant to 4011-139, you're asking to be, that the bonding company be relieved.
Yes, Your Honor.
Does the state have any opposition to the motion?
Not that I'm aware of.
Well, by statute, once he is arrested and taken into custody on a case, you have the right to be removed from jail, from the bond, I think. Let me look at that statute again.
Yes, Judge.
The interesting part of this is that there's been no forfeiture of his original bond in capias for his arrest, because I think it was not set until February, let's see, I'm sorry, it was set for June 17th, 2026 for status. Under the statute,
He's been in Georgia since April, Judge.
I represent Mr. Carson, and I'm not sure, is he incarcerated in Georgia? He was definitely released from the jail here, it was 9th of April.
He bounced us, oh, didn't.
the statute deals with the forfeiture of bail having to do with a forfeiture having been taken. It doesn't really apply where there's been no conditional forfeiture of the bond. It may be that your bonding company is asking to be relieved to avoid that, but I don't know how the statute would allow him to. They made the bond an accepted payment from the defendant. Then they're now asking pursuant to 4011-139A, which states that if the defendant whose release is secured under 4011-122 does not comply with the conditions of the bail bond, the court having jurisdiction shall enter an order declaring the bail to be forfeited. That means we would forfeit your company's bond. Notice of the order of forfeiture shall be immediately sent by regular mail by the clerk of the court to the defendant at the defendant's last known address. The defendant's surety will be served with sara facie upon the forfeiture and entered, and a capias shall be issued for the defendant. When the defendant who failed to appear pursuant to the conditions of bail bond is arrested on a capias, the surety on the defendant's forfeited bond is released. All of that contemplates the fact that there's been a forfeiture, and there hasn't in this situation. That may happen, but at this point, I think your client's motion is premature because there's been no forfeiture entered.
Yes,
So
Judge.
we need to try to get him back.
Yes, Your Honor.
So
Thank you, Judge.
anyway, their motion to be relieved is denied respectfully because it doesn't meet the conditions of the statute. There obviously may be reapplying at a later date. but-
Yes, Your Honor.
Judge, I think Mr. Howard and I were under the impression he was in our, so that's it.
You what now?
We were under the impression that he was in our.
I found out last week.
All right.
Thank you, Judge.
You had another matter?
I have two more, Your Honor. I
Are they
have
all basically motions to relieve a bonding company?
the Walton, Your Honor, I think that's on Your Honor's last page. Chase Walton, that is correct. It's a motion to be removed. And the fact pattern is the same, although he's not in Georgia, he's in Hickman County at this time.
There being a conditional forfeiture and under that statute that I just recited into it, your client would be entitled to relief, so as he's been picked up in Hickman County.
Yes,
You'll
Your Honor.
submit an order, please. I'll find that the bonding company is relieved and the defendant will be held without bond.
Thank you, Judge. You have it?
Ms.
Perfect.
Stevens, if you'll sign off on the order.
Thank you.
Mhm. And then your other one,
McCoy, Your Honor, he is incarcerated. I think he's been brought up to
Ronnie
plead.
Tosh McCoy.
Yes, Judge.
And that's, again, another motion to be relieved.
No, Your Honor, he's for plea.
Oh, he's your client.
Yes, Judge.
Is he here?
He was set for Zoom originally, but I believe that he was going to be
They were
transported.
going to bring him down for you. He hadn't been brought down yet. All right. We'll try to get him here as soon as we can. It'll probably be likely after lunch now, so.
Your Honor, I have to be in Montgomery County at 1:30 today, but I will come back as quickly as possible.
I'm not sure we'll still be here at one, if you go to Montgomery County at
The
1:30.
abyss, yes, Judge, it's the mini Davidson County. I loathe it, but there I'll be.
We do have 4 pleas for tomorrow
I'll make it work, Your Honor, if you would allow that.
to move it to tomorrow. I have to leave at lunch tomorrow.
I will be here I've been up since 3, Judge. I can be here at 04:30 tomorrow morning if the court is available. I'll be here.
You could be here at 4:30, is that what you said?
04:30? Oh, 4:30 in the morning, Judge, but I can be here anytime you ask me to, Your Honor. I would like to get him pled out. It's been a while.
Then we'll move Mr. McCoy's to tomorrow morning at 9 o'clock.
Yes, Judge. Thank you, Your Honor.
But it is for plea.
Yes, Your Honor. He just needs to sign. Oh, that's the other thing.
Do you want Mr. Flanagan's?
Well,
You know Ronnie Tosh.
Littleton always volunteered a lot.
I do.
But I think this defendant's in the same conspiracy case than I am.
Problem with having lawyers stand there, which we do all the time, is that occasionally you'll get someone who is upset about the fact that their real lawyer is not, their actual lawyer is not there with them, so.
No, Judge, I don't mind coming back in the morning if you'll allow that.
Do what?
I can come back tomorrow morning. That's
Tomorrow
totally.
morning will be all right.
Yes, Judge.
We'll do it at 9
Perfect,
o'clock.
09. And Your Honor, there's also another matter, Miss Crystal Wilkerson's case, Mr. Dillard.
Speaking of those type of situations,
Yes, Judge, I was just asked via text to stand in to get a new date, but I don't know that that's actually the case.
do you have the agreement that was executed? We started the plea, I think, at a prior date, started the plea, and he was unhappy with the fact that Ms. Wilkerson was not there and expressed some issues about that, so.
I spoke with her client this morning briefly and explained I did receive it, Ms. Bryson sent it to me in my text, so he was able to read it and said he did not want to accept that. So I explained to him that
But he does not want to accept the plea.
that is what he told me,
All right,
Judge.
then we need to set him a trial date.
Yes, Your Honor.
Let's bring it, do we have Dillard here?
Yes, Judge.
Bring him out, please. So we haven't heard anything from Houston County about Mr. Nicholas Harden Creech or arraignment? Good morning again, Mr. Dillard. We are here today for a final plea day on your case, and it's my understanding, talking to Ms. Stevens, that you have seen what your lawyer has been offered by the state to resolve your case by an agreement, and you decline to accept it, which is your right. So I'm going to set you a trial date. And General, do we know, this is a drug possession charge. Do we know when you want to set this?
It is probably a 3-witness trial, so it would be a 1-day trial.
Well, let's, we have State versus Cordarius Godwin. What about the State versus Richard Greer? Mr. Flanagan, is that case a go for sure? You want to set it behind the State versus Richard Greer?
What day is that, Judge?
September the 28th and 29th. You can put it on the 29th, that would be the second day.
That's fine, Judge.
All right, this case will be set for trial on September the 29th.
Thank you, Your Honor.
Who else? Let's bring out the next inmate. Let's try to get these inmates taken care of.
Kang Nguyen, also known as Andy Latran. Reset him from last month, attempting. What is going on? Mr. Nguyen was being supervised in Oklahoma for our BOP. He got new charges in Oklahoma and has resolved those, but he would like his probation officer originally supervising him in Oklahoma to testify at his hearing. We have been trying to hunt this person down. He is no longer employed by probation in Oklahoma, and Mr. Miller, my investigator, is having a rough time of it. Mr. Nguyen is very adamant this person testify. I don't know how long it might take us to find him at this point. I'd ask that we reset this a couple of months at this point.
Well, let's see, this is June. You'd be looking at, next is June. You'd be looking at July. What is your date in July? Yes. July 27th. All right, thank you. Anybody have anything that doesn't require an inmate that we're waiting on?
Your Honor, on page 5 of the docket, there is State versus Jack Dudley. This is a case where the defendant's presence was excused. He's incarcerated in Benton County. On this, he's got pending charges in Davidson that relate to the alleged violation in this case. We'd ask that the court grant a reset to the September VOP date, please.
September 30th.
Yes, sir.
All right, we'll reset to September 30th.
Thank you, Your Honor.
Patrick Meadows, who was downstairs. I don't know if he's been brought up here at this point. He is on this one. Well, if you want to wait, we can wait and get him out here, but we were going to reset him.
What are you doing with him?
The basis of his VOP is the case that was in sessions this morning, which has been bound over to circuit court. And ultimately, I think we'd like to explore mental health court for Mr. Meadows when that gets up here.
All right, so when do you want to reset him?
Judge Turnbow's next docket
is the
would be
mental
the
health judge. So
August, so.
He here in August? Turnbow? So that was August 27th? August 31st.
Very well. Thank you.
We do not need Mr. Meadows. They can transport him back to the jail. Anybody else have anything that doesn't involve an inmate?
I didn't realize Mr. Meadows.
You're right. We do need him. Mr. Baker? All right. What is it? Well, the reason it was reset, there was nothing to indicate why you need an extension. It was just basically it was a petition for an extension with no correlating evidence. If you want to tell me why, then let us place you under oath and we'll let you do that. So raise your right hand.
Yes.
Well, at this point, there was a final forfeiture or conditional forfeiture. Is that what it was? This says for an extension of a final forfeiture. When do you know anything about what's going on or why you need an extension?
Well, I put in for the extension a month before the forfeiture. I didn't want to do it day of the forfeiture.
Well, there was a conditional forfeiture that was issued in January of this year, and that normally we set it 6 months down the road.
For June 17th.
That would have been somewhere around that, yeah. But we granted an extension of your final forfeiture for June 17th of this year. The final forfeiture was originally in January, and then we reset it for June. So all I needed to hear from you is, are you making any efforts to locate him?
Yes, sir. Yes.
How long do you think that you need as far as an extension?
I wish I could tell you. I would love to tell you 90 days.
Well, how about we say
I am in search of him, though. I'm working with his sister to try and locate him.
I'm going to give you till January to see if that takes care of it, which is about as good as I can do right now. We'll reset it for January 27th.
Thank you, Your Honor.
All right. So as soon as we can get an inmate to bring out, I'm waiting on them, so.
Your Honor, this is Mr. Patrick Meadows.
Mr. Meadows is here to be arraigned on an second amended violation of probation. And I believe we've given you, or we'll give you a copy of the amended charge. You want a formal reading of that?
No, sir.
All right.
And if we could just keep him set on August the 31st.
We're resetting it for August 31st in front of Judge Josh Turnbow.
We'll probably have a court date. It's going to be an arraignment on once we get them all up here. So. Acknowledge receipt.
According to my list, it'd be Joshua Ray is next. Is that who? Mr. Peters, you are here to be arraigned on an indictment charging you with violation of the sex offender registry on 3 different counts. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, please.
All right, I'll appoint the public defender here in the office to represent you and give them a copy of that charge.
We accept the appointment, acknowledge receipt of the indictment, enter a plea of not guilty at this time.
Plea of not guilty is entered. We want to set this for status in September the 23rd. Ms. Lowe, are you going to be ready on Mr. Bradford whenever we can get him out?
I still have to speak with him.
Do we know if they've transported Nicholas Harden Creech or if he was supposed to be on Zoom?
Your Honor, this is Mr. Joshua Daniel Ray. He also needs to be arraigned on an amendment this morning, I believe.
All right, this will be a violation of community corrections, is that correct? All right, we have a first amended, we'll give you a copy of that to serve on Mr. Ray, or give him a copy rather.
Acknowledge receipt, and we waive any reading, Your Honor.
All right. Plea of not guilty is entered. Do you want to set it for that June date,
That would be fine, Your Honor.
which was June 29th? I don't know why I can't remember that. June 29th.
Thank you, sir.
Thank you. Mr. Baker, do you represent John Allen Wren? What happened to Mr. Baker? Sorry. When I finish with Mr. Wren, we'll break for lunch. Anybody that needs to talk to their client, this would be a good opportunity to do so. You bring out Mr. Guthrie?
Just need him to sign, and then I'll pass up the sheet.
All right.
I dealt with Miss Sarah on that one.
So by my count, we have 5 cases for plea tomorrow. Now, we had 4 and we've added 1 today.
We're gonna get your jail credits.
Mr. Flanagan, what else do you have?
He's got a medical condition. He takes medication. Before he was here in general, so he was here this morning. 1 or 1:30.
Let's do 1:30.
Back with him.
All right, I've been handed a document indicating that Mr. Anthony Cooper Guthrie, who is on page 8 of the docket number 2019 CR 337, on a charge of probation violation, that he is going to waive a hearing and admit his violation, be revoked on his probation, and put his sentence into effect with credit for all time served. Is that correct? All right, raise your right hand, Mr. Guthrie.
Ma'am.
State your full name for the record.
Anthony Cooper Guthrie.
Mr. Guthrie, you're here today on a charge of probation violation. I want to make sure you understand what your rights are. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
You understand that if you had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by pleading guilty, you're waiving your right to that hearing and to that appeal? All I'm going to do is revoke you to serve your sentence and make sure you get credit for all your time.
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand all your rights?
Yes, sir.
Are you pleading guilty to your probation violation?
Yes, sir.
Then upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence with credit for all your time served, and we will make sure that you have an order entered supplying with all the correct time, okay?
Yes, sir.
All right, thank you.
Thank you. Thank you, man.
All right, we're going to then break for lunch. We'll be at lunch until 1:30.
In this chaotic eviction court session, a judge grows visibly frustrated as landlords, tenants, and attorneys repeatedly appear without updated information, forcing the court to untangle confusion over rent balances, key returns, and pending move-outs. One tenant disputes the amount she allegedly owes after turning in her keys, prompting the judge to stop the hearing and demand that property management verify the facts before proceeding. As the confusion continues, the judge openly vents his frustration with attorneys and apartment managers who arrive in court without communicating important updates. Do they expect me to be a mind reader up here? The courtroom then shifts to another emotional eviction case involving a woman who owes nearly $4,000 in rent and fees. She explains that she receives payments from a settlement after being injured by a drunk driver and asks for more time to pay. Instead of ordering immediate eviction, the judge grants her an extension, but warns that the full balance must be paid by the deadline or she must move out. Moments later, another eviction hearing falls apart because of poor Zoom audio, leading the judge to jokingly tell the tenants to drive across the street to the courthouse so everyone can actually hear each other. By the end of the session, one case is completely dismissed after management finally confirms the tenant had already returned the keys, leaving the judge wondering why crucial information was never shared before court began. What starts as a routine housing docket quickly turns into a frustrating lesson about communication failures, unpaid rent, technical problems, and judges trying to keep an overloaded eviction system moving. Do you think landlords and tenants should be required to resolve basic communication issues before bringing eviction disputes into court? Like and subscribe for more real courtroom moments.